Hello. Good afternoon again to our viewers on Facebook. My name is Dick Kubana, legal manager here at Legal Aid South Africa. This is a follow-up to the discussion we had last week on the rights of arrested, detained, and accused people, Section 35 of the Constitution. This Facebook live broadcast that we're having are focused discussions that we're having around Human Rights Month. As you know, March is Human Rights Month, and we're using this time to spread awareness of our human rights and answer any questions that you may have about your rights. As you all know, tomorrow is Human Rights Day, 21st of March. I'm sure some of you here are already ready to celebrate the day that we attained our freedom in South Africa. Some of you will be traveling to faraway places to spend Human Rights Day with your families and enjoy the long weekend. If you're traveling, please be safe on the road. We'll see you again when we have our next Facebook live broadcast. But please note, during or after this broadcast, you can leave comments or questions about you or about any question about human rights. We will try our best to respond to your questions, but if we are unable to respond to the questions today, please look out for a message with our response in the future. If possible, we can also respond to your questions in a subsequent Facebook live broadcast. And please note, if you require legal advice, you can call our toll-free legal advice line on 0800 110 110. This is the number right behind me here on the screen. Please take it down. This is the number of our free advice line. The number is 0800 110 110. You can call us weekdays between 7 a.m. and 7 p.m. And if you cannot call us for some reason, you can send us a please call me. If you send a please call me, one of our call center agents will call you back. The number that you must dial to send a please call me is 079 835 7179. And please remember, you must like and share this video to spread the word on human rights. Today, we're going to continue our conversation on Section 35 of the Constitution, and we'll be answering all your questions. But first, I'm going to start with two questions that some of our viewers asked after our previous broadcast. We got a lot of interest after our last broadcast on Section 35 of the Constitution. You can see how South Africans take their rights so seriously. So we get very good responses, and we got questions which we responded to, but we've got further follow-up questions. Now, our first question comes from Nkosi Mkunu Dlamini. Nkosi asks, why does Legal Aid South Africa start representation on the day of the first appearance and not at the time the accused is detained? Now, this is a very good question. You remember our last discussion was dealing with not only people that are already appearing in court, in other words, accused persons, but also people that are detained, whether it is before their trial or after their trial, and people that have just been arrested, because your rights start there as an arrested person. And as you will see, today we'll deal in detail with rights that you have, at the stage that you're going to appear in court or when you've appeared in court. Now, it is true. Ngozi, every arrested person is entitled to have a lawyer. So from the moment you're arrested, you're entitled to have a lawyer. In fact, I'm sure you may have read in the media that some people, even before they're arrested, they're taken to the police by their lawyers. Or they make arrangements with the police and say, we understand you're investigating a case against me. I'm not running away. I want to face the law. I'll come to your station on such and such a day. And they come there with their lawyer. Very good arrangement. Now, Your question is, why don't we do the same here in Legal Aid South Africa? And I'll tell you what the answer is. Firstly, cost. We do have resources, to provide the services that we provide, but these resources are not unlimited. It is your taxes that we use to provide the service that we provide, but these resources are not entirely unlimited. So in most cases, we cannot be in a position to just have someone on standby at a police station in case someone is arrested. As you know, of those people that are arrested, not everyone requires legal aid. It can happen that in a day, a person is arrested and that person chooses to have their own lawyer, in some cases no lawyer at all. This is not a choice that I advise, but sometimes this does happen. But however, I must advise that we have actually done studies or pilot studies to research the feasibility of doing this. In other words, of going to the police stations, finding people that may require legal representation to see how we can assist. In the previous pilot studies that we did, the numbers were very low. So in other words, we did not find a lot of people who required legal representation at that stage. This could be because of a number of reasons. Some of the reasons could be that people are still undecided at that stage. What we often see also is sometimes people would like to instruct a lawyer of their own choice, believing that they will have the finances to do so, or maybe their families will support them in doing so. And only when it turns out they do not have the financial resources to pay for their own lawyer, they then choose to apply for legal aid. So if you post a person at a police station for a whole weekend, hoping for someone to apply for legal aid, it does happen that at that moment people haven't thought things through because they've just been arrested. But I must say that we are, however, still doing ongoing research on this subject. This is a service that not all legal aid agencies in the world provide, but in some very developed countries, the service is provided where you can have a duty lawyer who's available in all police stations to see if there are people who require assistance and the assistance can be given. We do not rule out the possibility that in future, Legal Aid South Africa will also be in a position to do this. With available resources, we will only be too happy to ensure that you've got legal representation from the moment you're arrested. This we can do by, for instance, getting the police to call us if they arrest someone. Already, we do have our numbers at all police stations. We put our numbers at police stations in correctional centers so that people can easily access us. But I must tell you again, if a person is arrested, they have to appear in court within 48 hours. And at that moment, so at least 48 hours after the arrest, we can assure you that there will be someone from Legal Aid South Africa at any court in the country who will assist you in taking down the legal aid application. Now, I'm going to move on to a question that was posed by Mukhodi Ngwato Hasaho. Mukhodi asked the question, how do famous people get bail at police stations, but ordinary people must appear in court first? Now, Mukhodi, bail is essentially an issue that a court decides on. So in the normal course, you get granted bail in court. However, there are some small minor offenses where the police can grant you bail at a police station. These are only some very minor offenses. You cannot get bail for serious offenses at a police station, especially if it's granted by the police. For some minor offenses, the police can grant you bail. So if you're arrested maybe for reckless and negligent driving, or sometimes drunken driving, or some petty thefts, the police can give you bail at the police station. However, you must note that the police obviously have got a function or a mandate to combat crime, arrest, those that are suspected of crime. So will not necessarily take the initiative to give you bail if you're arrested, because obviously, this is their mandate is to arrest people and then take them through the court system. So in many cases, if you are not legally represented, you may not know the processes. But also, can you imagine if you're arrested, you're not legally represented, phone now it's in storage, you don't know who what the processes are. So on your own, it's a little bit difficult for you to apply for bail at a police station. If you're legally represented, in most cases, this is not too difficult because your lawyer will know if this is the sort of offense that the police can get bail for, or if it's an offense that you must apply for bail at a police station. It's got nothing to do with being rich or poor. It's got to do with specific offenses, and obviously just following the right procedures to apply for bail. Thank you very much. These are the two questions that we got as follow-up questions from our last discussion. But today, we continue our discussion again on Section 35 of the Constitution. Very important. Now, in our last discussion, we concentrated mostly on the aspects from arrest to detention. This discussion will move on to what happens now with regards to you appearing in court and what rights you've got from that stage on. Now, very important, the overarching or overriding right for people appearing as accused persons in court is that you have a right to a fair trial. This is very important. No one will be happy to be arrested, be taken to court, and have a trial which is unfair, where they haven't exercised any right. You just hear, this is what you accused of, now you're going to be sentenced to whatever, or this is what is going to happen to you, but you never had a fair trial. Now, what is a fair trial? There are many different components to the right to a fair trial. Now, these are the components that are detailed in Section 35(3) of the Constitution, and I'll go through each one of them with you. The first component of a right to a fair trial is you must be informed of the charge with sufficient detail to answer it. So, muntu mai eboshiwe angeke ngene court bese bethi ayi wena si ikala lakho lokuthi utshontshile bangakutshela ukuthi utshontsheni kuphi yakabani. The charge must have sufficient particularity. You must be able to know what you're defending yourself against. So they must at least tell you, oh, this is what you say. It said that you stole someone else's cell phone. And who is that someone else? You stole the cell phone belonging to so and so. All right. When is it alleged that I stole it? On such and such a date and such a time. Where is it alleged that I stole it? In Johannesburg or in Clocolan or wherever. This is what it means to be informed of the charge with sufficient detail so that you can answer it. If the charge is sketchy, awukwazi ukuziphendula, awukwazi ukuzidefenda kuleyo case. That's the first important aspect of the right to a fair trial. Let's move on. You have to be given adequate time and facilities to prepare a defense. I'm sure you all know, if you are arrested, they just don't hold you to court and then say, yeah, now what do you say about this charge? No, you have to have time to prepare a defense. But this also means that you need to have time to consult. You may want to go and speak to a lawyer about this. You may want to go and speak to your witnesses about this. So you have to have time to prepare your own defense. Now, you are also entitled, or you have a right to have a public trial before an ordinary court. All right, now you're going to answer. This is what we're accusing you of. No. Your trial must be in a public place where members of the public have got free access. They can hear for themselves. They can see for themselves. They can also make their own judgments, what they think of the case, if they think you committed the offense or you didn't commit an offense. This trial must take place in an ordinary court. You've also got the right for your trial to begin and conclude without unreasonable delay. This is a very, very, very important right. This right, when people speak about it most of the time, they refer to it as the right to a speedy trial. So in other words, if you're accused of something, you want to have time to prepare, but your trial must start, it must finish. You don't want a never-ending trial or to have to wait forever for the trial to start. You have the right to a speedy trial. This is why all of us involved in the legal sector, we always try our best, and we have got many projects where we try to prevent delays in finalizing cases, because you've got the right to a speedy trial, to have your trial start and finalize within a reasonable time and without any unreasonable delays. Now, you also have a right to be present when being tried. So, if there's a case against you, you must be there in court when the trial takes place, so you can hear and see and answer to whatever allegations are against you. This is a very important right. In South Africa, we take it for granted, but I'll tell you, there are some countries where you can be tried in absentia. In other words, you can be tried while you're not there. And then you will hear, this is what you've been sentenced to. I just saw a media report yesterday, a very famous artist from the DRC. His name is Kofi Olomide, for those who like Kwasa Kwasa music. And he was sentenced by a court in France, and he wasn't even there. So maybe he got his sentence by email. In South Africa, you have to be present when your trial takes place. Now, here's another right that talks a lot to the work that we do. You have a right to choose and be represented by a legal practitioner, and to be informed of this right promptly. So, you have the right to have a lawyer to represent you, but you've got choice also. So you've got the right to choose that lawyer. But over and above that, you must be informed of this right promptly. Any of you who have ever been to a court, you will know that if a person appears in court for the first time, this is the first thing that a magistrate will deal with as the accused. Do you want to be legally represented? If you say yes, who is going to represent you? Have you got a lawyer? Then you say, yes, I've got, or I'm going to find a lawyer. And if you cannot afford a lawyer, as we go further down, you will see what rights you've got if you cannot afford to have a lawyer. The courts will bend over backwards to ensure that you have a lawyer during your trial, because it is beneficial to you to be legally represented. Now, next right applies where you want to be legally represented, but there is no money to pay for your own lawyer. Lokori have a man. Karari cheredio badera mwemereri isiho. If you find yourself in this situation, the Constitution says you have the right to have a lawyer assigned to you at state expense if substantial injustice can result. And you must also be informed of this right promptly. So, if you cannot afford to have your own lawyer, a lawyer must be assigned to you at state expense. In other words, at no cost to you. Now, some people misunderstand this, right? And they think for a lawyer to be given to you at state expense means you will be given a state lawyer. Now, the government has got its own lawyers, but those lawyers do not represent accused people. They are called the state attorney. They represent the government itself. If you got a case against the government, those are the state lawyers, the state attorney. They represent the government. They will not represent you if you appear as an accused in court. So, lawyer provided to a state expense doesn't mean you'll be given a state lawyer. In this country, if you cannot afford a lawyer, you have to apply for legal aid. In other words, you have to come to us. You don't have to come to us. There in court, there will be someone from Legal Aid South Africa who will take down your application. We are not state lawyers. We are an independent organization. We are funded by the Treasury, but we are not state lawyers. We are your lawyers. We represent your rights. And we ensure that the state does not contravene any of your rights, that your rights remain protected and they remain intact. So the fact that you do not have financial resources or you do not have money is not a limitation on any of your rights to have legal representation in a court. It is, as I said before, the courts will bend over backwards to make sure that you have a lawyer, because it is not easy to conduct a case on your own if you do not have knowledge of the law and how it works. It's a totally different minefield that I never advise anyone to navigate on their own. Now, next right, if you are appearing in a court, you are presumed innocent. You have the right to be presumed innocent. So you're not appearing there. If someone said to you, all right, you are a thief, you must come and appear in court because you stole at whatever place. No, you're not a thief. You're just accused of committing an offense. It still has to be proven. So you are still an innocent person. You're just innocent like anyone else. This is your status when you're appearing in court and you've not been found guilty of any offense. But because you're innocent, you also have the right to remain silent. It's not for you to prove yourself guilty or to prove yourself not guilty. Whoever accuses you of doing something must come and prove it. You don't even have to say anything. You can just remain silent and listen to what they have to say. It's only if they give evidence, you know, that establishes a prima facie case against you that you may have to answer to that evidence, to whatever they say. But otherwise, you've got the right to remain silent. You cannot be asked to say anything or to give statements to the police or whoever asks you for a statement. You can only give your case or give your version of events to your lawyer, who will use this, obviously, to protect your rights, to defend you. You do not have to testify during the proceedings. As I said, you only need to testify if a prima facie case is made against you. But if there's not such a case, if the state has not set out facts on which you could be found guilty, this is what I mean by a prima facie case. The state has got to lead evidence on which, you know, a reasonable person could find you find you guilty before you have to answer to that case. Otherwise, the court must let you go. Now, you have the right to lead evidence, to give evidence yourself, and to challenge evidence. By giving evidence, we mean that you can go then and explain your version of events. But you don't have to do it yourself. You can use your witnesses. You can call witnesses to come and give your version or support your version of events. And when we say you can challenge evidence, it means whoever comes testifies in court, you can cross-examine them. You can cross-examine them on whatever they say. Try to show the court that what they're saying is not true if you're pleased that you're not guilty of committing the offense. Very important rights. Now, you cannot be compelled to give self-incriminating evidence. As I said, you are innocent. It's not for you to prove yourself guilty. Someone else must come and present their case and say you're guilty on this basis. It's not for you to give self-incriminating evidence. Now, you have a right to be tried in a language that you understand. And if you cannot be tried in a language that you understand, then there must be someone to interpret from whatever language to your language. This is very, very important. Court proceedings in South Africa are mostly conducted in English, in Gesingis. Some people do not understand English. So how are you gonna prove yourself innocent in a case if you can't understand what is happening? Now, apart from the proceedings being in English, there will be some words, some big legal words that will be used there, even Latin words. I just mentioned the word prima facie, and I apologize for it. I explained what it means. These are the kind of words that are used in court now. How are you going to defend yourself if you don't understand what the people are saying, the magistrate, the prosecutor, the lawyers? So you must be tried in a language that you understand. But if you cannot be tried in a language that you understand, then there must be an interpreter who can interpret from, say, English to isiZulu or whatever language you speak, or Afrikaans, or whatever language you speak. This is very important. You have to understand all the proceedings. There should be no gaps left. You have to understand everything that is happening in the courtroom. Now let's move on to the next right. Now, if you are appearing in court, you cannot be convicted or found guilty of something that was not a crime at the time that it was committed. Now, let's say in 2010, something happened. You went to a World Cup soccer game, and at the World Cup soccer game, you took pictures with the referee. I'm just giving an example. You took pictures with the referee and you were very happy about this, or the team from Germany that was playing there, and you like these pictures and you distribute them on social media, on Facebook and on Twitter. You like these pictures from the 2010 Soccer World Cup. Now let's say in 2019, the government passes a law that says that no person is allowed to publish any pictures of a big sporting event without permission from the Minister of Sports. If you do it, it's a criminal offense. They can pass such a law. It's possible for one reason or another. Now, you did all this in 2010. The law is only passed in 2019. They can say, oh, by the way, you also did the same thing in 2019. In 2010, it was not an offense to do this, to publish these pictures. So, and it's a defense, and it has happened for many offenses. We see it from time to time, that a person is arrested, is charged for committing a certain offense, but when we check, we find, oh, the alleged incident actually took place before that became an offense. It has to have been a criminal offense at the time that it is alleged it was committed. Now, linked to this also, you cannot be tried for an offense for which you have previously been acquitted or convicted. In other words, you've been found guilty or found not guilty. And you may not believe that this happens, but it does happen, that you are charged for a certain offense and you're found guilty or you're found not guilty. So the trial has come to an end, finished. But a couple of years down the line, someone says, this person for what he did, we could have charged him with a much more serious offense. So let's call him back to court and charge him with this offense. If you've been charged on the same facts and you've been found not guilty for that offense, or you've been found guilty, that is disposed of. You can't be tried it for a second time again. You cannot you face a trial for the same thing over and over and over again. Believe me, it does happen. You'll think, but they will know I've been tried before. But believe me, it does happen. Sometimes we have to enter a plea like this, that you have already been tried for the same offense. Now, if you are found guilty of the offense you're charged with, and you have to face, a sanction by the court, you must have the benefit of the least severe of the prescribed punishments. If the punishment has been changed between the time that the offense was committed and the time of sentencing. So again, I'll explain to you what this means. Let's say in 2010, let's use the year 2010 again, very exciting year when we had the World Cup here. Let's say in 2010, you committed an offense. You stole 600,000 rand. And at the time, if you stole money, you could be sentenced to a maximum of 10 years imprisonment. That was the law then. Let's say that was the law then. But subsequently, in 2012, the Parliament passes a law that says, well, if you're convicted of stealing an amount over 500,000 rand, you must go to prison for 15 years, a minimum of 15 years. In other words, this is now a more severe sentence than what it was in 2010. Now, you committed the offense in 2010. The law changed in 2012. Let's say you're only arrested now in 2019 and you face trial and you're found guilty. You cannot be sentenced to 15 years imprisonment. It's the applicable sentence now. But you must be, because there's a difference between the sentence, the law in 2012 and in 2010, you must have the benefit of the less severe sentence. So in other words, you must be sentenced to the same sentence you would have been sentenced to in 2010. I think that makes perfect sense. Now, we've already got a question, but I want to read a few more sections before I deal with that question. Now, if you have been convicted or found guilty of an offense, you have a right of appeal or review to a higher court. Now, a lot of people may know this, that the fact that a court has found you guilty does not mean that is the end of it. Anyone can make mistakes, or a court can find you guilty, but another court may say, no, that court shouldn't have found you guilty. This is why people go on appeal. They appeal the finding of another court. Even a sentence, the court can say, you must pay a fine of 100. I don't want to use, you must go to prison, because that is not the only sentence. People will think when you're arrested, you just going to prison. No. Let's say court says you sentenced to a fine of 10,000 rand. Another court may say, no, but 10,000 rand is not appropriate. You should actually have been fined 1,000 rand. That happens on appeal. So if you've been found guilty of an offense, you've got the right to appeal to a higher court. The remaining sections of Section 35(3) are self-explanatory, that wherever information is be given to you, it must be in a language that you understand. We've covered this. If you have to be given information in terms of this section, it must be in a language that you understand. Another important section, if evidence is obtained in a manner that violates the Constitution and the Bill of Rights, that evidence cannot be admitted against you in a trial. So all evidence must be obtained lawfully. If there's a breach of your rights in obtaining evidence, that evidence cannot be used in a trial. And there are many instances where your rights can be violated. If, for instance, a search without a warrant, searching your premises without a warrant. In the normal course, the police should have a warrant to search your premises. There are some exceptions where they can search without a warrant, but in the normal course, to obtain evidence, the police must have a warrant to search your premises. The police cannot assault you to extract some evidence from you. So if the police arrested you and they tied a plastic bag around your head or something so that you can own up to something, that is not lawful. That is not evidence that can be used in a court or in a court of law. The courts do not deal with dirty evidence. That is what I call dirty evidence. So only evidence that is obtained lawfully can be used against you. Now, I just want to go now to a question that has been sent to us by Anonymous. And Anonymous says, so you cannot be tried for stealing one person's car more than once. He says, that is his question. He says, so you cannot be tried for stealing one person's car more than once. Now, this question is subject to some interpretation. You can steal one person's car more than once. It is possible. So let's say you really like this, you really like your neighbor's Polo. So you find it parked in the driveway one day and you steal it. And then it's recovered. Then you can be charged for that offense. After 3 months, now you want to go on holiday and you decide my neighbor's Polo again. Then you steal it again. That is stealing it more than once. You can still be tried again. Those are two separate offenses of theft. But you cannot be tried more than once for just stealing it once. So that initial stage, a theft that you committed, let's say you arrested for it and you tried for it and you're found not guilty. That is the end of the matter. The state cannot come after 1 year and say, oh, by the way, we obtained another statement now from another witness who saw you stealing the Polo. Last time you went to court, you were found not guilty, but now we've got stronger evidence. Or we found video footage, it shows you stealing the car. You must go back to court and be tried again. No, you cannot be tried again. Doesn't matter what evidence they've got, you cannot be tried again for the same offense for a second time. But for stealing the car more than once, yes, sure, Anonymous, you can be tried for stealing the car on a second occasion or a third occasion, or maybe the neighbor's other car. You know, every theft is a new offense, and for that you can be tried. Now, you also ask Anonymous if I can give an example of Section 35(3)(m), and if I'm not mistaken, this actually relates to the same question, because you say you got 3M says you cannot be tried for an offense in respect of an act or omission for which that person has been either acquitted or convicted. This is exactly the same example I gave you. So you've been arrested and you found not guilty, but then suddenly some star witness appears, or some evidence appears, or some strong evidence, against you appears, and they say, but now we've really got evidence to show that you stole the car. If you have been tried and found not guilty, you cannot be tried again. In the same vein, if you've been tried and convicted, so let's say you were found guilty of stealing this car, and you were convicted, and someone comes around and says, we actually found evidence to show that you hijacked that car. So you can get a heavier sentence. So we're going to try you again now so that you can be sentenced to the appropriate sentence for car hijacking. No, sorry. You've been tried, you've been convicted of that offense. That is the end of it. They cannot call you back again. But again, as I say, in the example of the neighbor's Polo, if you steal it more than once, or you steal it every Friday when you want to go out drinking, sure, you can be tried for the offense committed every Friday. Now, this ends our discussion on Section 35 of the Constitution. We are sure to have a lot of other interesting discussions on various topics. This is something that we like at Legal Aid South Africa, to educate the public, to tell you of your rights so that you know at any given moment where you stand, where to go, and what to do. So we are sure to talk to you again in the future about these rights. We thank you very much for joining us in our discussion today. Please feel free to send us any further questions you still have. We are going to reply to your questions. Send us a Facebook book message, but you can get instant legal advice by simply calling our free advice line. The number for advice line is right behind me, 0800 110 110. You can call the advice line on weekdays between 7 a.m. and 7 p.m. and our very capable call center agents will be able to give you the assistance you require. However, if you cannot call us and you want us to call you, send a please call me. The number to send a please call me to is 079 835 7179, and I guarantee that we will call you back and give you the help that you require. Our next Facebook discussion will be on Friday, the 22nd of March. Please, our Facebook viewers, join us again. During this discussion, we'll be talking about access to courts. This is Section 34 of the Constitution, another very important section of the Constitution, Section 34 of the Constitution. Please send us any questions you may have, and remember, like and share this video so that you can spread the word on human rights. To all of you, please enjoy Human Rights Day tomorrow, 21st of March. Please travel safely. If you're traveling out to spend the day with your family, or if you're going to spend the long weekend in various parts of the country, South Africa is a country of travelers. Travel safely. We'll see you next time.